Good afternoon, everyone, and welcome to today's webinar about the role of the union rep in the conciliation process. My name's Anna from the TEC, and I'm delighted to be joined by two guest speakers from Acas. We have Nicole and Tony, and we'll be handing over to them in just a second. Just a little bit of housekeeping. We have live captions, live subtitles on today's webinar. There's a green button underneath the video that if you click, it will open the captions in a new window. So please do that if you would like to read what's being said. As ever, our chat panel on the right-hand side is nice and busy already. We love hearing who you are, where you're from, your union, your workplace. So please do keep introducing yourselves in there. Something a bit different today. We've got a poll for you, our viewers. So underneath the transcript button, there's a button that says polls. There are 3 questions in there that we just want to know a little bit more about your experience with Acas, how you might have used Acas's services previously. We've already had a few hundred votes, which is fantastic. If you've not yet voted, please go to the polls and vote. It's just simple clicks. You don't have to type anything. We'd love to hear questions from you for our speakers. So again, if you've got a question, please post it in the Ask a Question section, which is again at the bottom of the screen next to where the polls are. We might not be able to get to every single question, but we'll do our best and we'll try to answer as many as possible. So I expect that we've all heard of Acas. But we might not all be experienced or know a lot about what they do or have a lot of experience of working with Acas. So that's why it's really good that we've got both Nicole and Tony here today. So before we get going on the meat of the webinar, I'm just going to ask each of them to introduce themselves very briefly. So Nicole, you first, please.
Oops.
No, you can, you're, there we go.
Thanks very much. And there you are. I think I should introduce myself as the person who obviously can't operate the mic on a webinar. So
not at all.
Apologies for that. My name is Nicole Clark. I work in the policy section for individual dispute resolution in Acas, and I've been with Acas for about 21 years now.
Amazing. Thanks, Nicole. And Tony, can you introduce yourself, please?
Yep, sure. Hi, everybody. My name's Tony Lowe. I'm Senior Policy Advisor and Nicole's dog's body. She gives me all the work to do. I've been with Acas for over 20 years as well. I've been a conciliator, so I've got a good grasp of how our conciliation works.
Fantastic. Thanks so much. So first of all, Nicole, can you please give us a bit of an introduction to Acas and an overview of what you do and crucially, the role that you play in the conciliation process in the workplace, please?
Sure. Thanks very much. Well, the role of Acas, and I'm sure many of you in terms of your dealings with Acas, you'll know that traditionally we were sent copies of all tribunal applications that are lodged, and then we have a statutory duty to talk to the parties to see if we can help you to reach an agreement, which will mean you don't have to go to the tribunal at all. In more recent years, that there's now a process called early conciliation. Again, many of you probably know about that, which means that before you lodge a claim at the tribunal, what you would do is tell Acas that that is your intention. And then there's a period of time where we can start that conciliation early. So in relation to dispute resolution, which is probably going to be affect many of the members that you represent and advise, that's probably an area that you will find that you would deal with me or with the conciliators within Acas. It's in relation to trying to find that resolution to dispute. So when we were asked to come along today, we were really pleased to be able to have a chance to chat with you all, and hopefully this is going to feel more like a conversation than it will anything else. That would work well for us. And we were told that most of the people who'd be coming along to the webinar were lay members who many of you will have a day job within the organisations in which you work. So we wanted to kind of get a feel for what your experience was of working with Acas or liaising with Acas in the past. And hence, that's why you'll find that those poll questions were asked around the sorts of things that you're doing. And it's really interesting. Thanks very much for voting on that, because we can see that a lot of you have contacted, nearly 2/3 have contacted the Acas helpline. A big majority of you have looked at our website, but probably only just over 1/3 have actually been involved in the conciliation process. So that's really helpful. Thanks very much for answering that, because it means that the layout we had to talk to you today, I think we can make sure that it fits some of the experience that you've got. What I wanted to do is to start off by showing you a little bit about that website, but it looks as though many of you have looked at it already. So we'll whiz through that and make sure we don't take up too much of your time on it. We then want to talk about what we're going to call the journey of a dispute, which is often the different stages that a dispute can go through, and some of the language that's used around that. People might get confused between early conciliation or conciliation once a tribunal claim is lodged. So just look at what the stages are. And then maybe make the bulk of this a conversation really about what we might call the top tips if you're representing someone who's actually in conciliation, so that you can work with your members and make sure that you've got their best interests and get the most out of conciliation. So that's really what we're hoping to do today.
Fantastic. Thank you, Nicole. So it would be really helpful. This is a question for the audience, actually, before we move on to the next bit of the webinar. Is one of the poll questions that we and Acas have asked you is, have you represented a member in the conciliation process before? And like Nicole said, it's about 1/3 of the people who have answered. Obviously, we don't want you to share confidential information or the names of people, names of employers, etc. But it would be, what we love is hearing about what is happening in workplaces with our reps. So if you briefly tell us in the chat panel how you represented a member, like what the subject was of the conciliation process that you were involved in, that would be really helpful, just so that we can tailor the kind of information we give out to you, not necessarily just today, but in future training sessions. Right, so back to you, Nicole, and we'll keep an eye on the chat as we're talking of this information coming in. So let's get going, like you said, with the Acas website, that you want to show a few areas to our audience about where they can find information that would be helpful to them. Are you going to be sharing your screen?
Yes, I'm going to try and do that. So fingers crossed, everybody, that this works.
For it.
Okay. So I don't, is that working at all?
Not yet. You need to, you've turned your camera off, but can you click on the little icon that looks like a laptop? It looks like an open laptop with an arrow in it.
Right, let's try that one. Tell me if that's starting to come through.
There it is. Right.
Yep.
There we go. Everyone can see that now.
Smashing. Okay, so from the poll, what was clear is that many of you have looked at the Acas website, and I'm really hoping that it's been a useful experience for you as well. Just to tell you that, like a lot of organisations, we're constantly trying to refresh the website and make sure that the way that we lay it out is based on going back to our users and getting their feedback on it. So a lot of this layout, which many of you may realise changed in the last year or so, is actually based on users telling us what was useful for them. So these top tabs along here basically will mean that you can get to the right place a little quicker. Just to cover some of the ones that you may not have looked at more often, I don't know, but you'll see here we've got a tab called Research and Commentary. Some of you might find that useful because Acas does do a lot of research in different parts of issues related to the workplace. So you might be able to read some of those actual papers that have been written. And down here, we've got a couple of areas that we call latest thinking. It's kind of the hot topics that are going on in the workplace at the moment. So I'm sure many of you have had debates about things like flexible working and hybrid working, given that restrictions have been lifted following the pandemic restrictions. And this is now a really hot topic in the workplace. And of course, supporting women through menopause whilst they're working as well. That's a very hot topic. So it's an area of the website that if you're interested in looking at some of those, do take a look at that page. I'm sure you'll find it useful. There's also our training page, from which you can actually find some training courses. And like yourself, we do some webinars as well. And you'll be able to see that there's webinars on different subjects there, with a list of some of the webinars that you may have missed down at the bottom. Again, you've got to register, but if there's anything there that you would find useful, by all means register and have a look at some of those. So as well as other parts of the training page where you can actually book in for a training course if you'd want to. Today, I really just wanted to draw your advice as lay reps. Probably the areas you're probably most interested in is the advice page, which is split up into different areas. This may look similar to the sorts of websites that your own trade unions have. We know there are some excellent websites out there which are hosted by the trade unions. So it may be that this looks similar, but it appears from the poll that many of you are looking at our website too. And if that's proving useful for you in looking up employment rights under some key headings, then I hope that this sort of thing, is where you would go to. It's split up in different ways. You can see here, just picking at random, pay and wages. If you had a member that came to you and asked about pay slips, you'd be able to have a look at that. And there's some general information that hopefully would be useful to you as a lay rep that you could provide to your members. So I suspect the advice area is going to be one place in the website that's going to be particularly useful to you. The next bit that's going to be useful and ties in more with the sorts of things we were going to chat to you about today is really the dispute resolution page. And here you'll see on these main tiles, there's an area that looks at early conciliation. And that's split up into different pages, as we'd call it, that will give you information about the early conciliation process. Do have a look at that. And please do ask your members to have a look at that if what they're going to do is they're going to make an early conciliation notification, because that will give them the heads up really as to what they can expect. So hopefully that would be an area that people would find very useful. And the other main part of this page that people really find useful is if you're going to make an early conciliation notification, use this link here and it'll start to take you through to a set of pages which you can then follow to literally give you information and take you through to the form itself. That form being known as the early conciliation notification form. You hit that button and it'll be a form that leads you through how you actually do it. So you've all seen the website. Great that you're using it. Be great to have some feedback as to your experience of it. But hopefully those two main sites were the areas that we really wanted to just take a couple of minutes to draw your attention to today.
That's fantastic. Thank you, Nicole. Just one quick question from me. Are we finished with the website now? Because if so, I'll turn off that video stream.
Yeah.
Okay, thank you. So I'm just trying to switch your video back on. It seems to have gone for a minute. Okay, it's a bit of a wobbly connection. Not to worry.
Sorry.
We can still hear you loud and clear, which is the main thing. So next, it would be really helpful if you could talk us through the journey of a dispute resolution, please. Especially what is the typical journey a rep would take when they have to represent a worker through early conciliation. I think this would be really relevant to our audience because if they're going to be involved in the process, this is where they're going to be.
Over to you, Tony.
Yeah, thanks very much. Yes, I think when we talk about the journey of a dispute, what we talk about really is the interplay between what's happening internally, what happens in early conciliation, what happens with a tribunal claim, and further conciliation that might occur during that process. So I suppose the natural starting point, if you like, is probably mentioning the significance of the internal discipline and grievance procedures. Now, I'll hold my hands up. I suspect most of you will have a lot of experience of supporting and representing members through disciplinary and grievance procedures. So I'm probably covering familiar ground, and I'm not going to dwell on it, but apologies. But just to say, I think the important point is that obviously a failure to engage in internal procedures can have implications further down the line. And what I mean by that is that if a dispute ends up in an employment tribunal, then under the Acas Code of Practice on statutory and discipline procedures, which a tribunal would take into account, the tribunal can make an adjustment for failure to follow that kind of procedure, and that adjustment can be about around 25%. So it's important, and we would certainly advocate using an internal procedure where there is one, where time permits, and I'll come on to say something about time limits a bit later on during our presentation. But assuming that things can't be resolved internally and a tribunal claim is being contemplated, then there is a legal requirement to notify Acas first under the EC Rules of Procedure before you can make a claim to tribunal. And as you've just seen, Nicole's just shown you that it's a very simple process. It means filling in a notification form, which is some very basic details about who's involved, the names of the claimant, the names of a respondent. Once it's submitted, we'll start to have a conversation with you. The initial early conciliation period lasts for 6 weeks now. It used to be 4 weeks with a possible extension for 2 weeks. By default now it's 6 weeks. And of course, during that period, there'll be conversations with yourselves, conversations with the other side. And the idea is to try and focus everybody's minds on trying to reach compromise, though of course we recognise it's not always possible. But if we can get there, then of course we can record what's agreed on what's called a COT3, which is a simple contract between the parties. If we can't manage to reach agreement, then what we'll do is issue a certificate. And that certificate, if you like, is your passport to make a claim to tribunal, because as part and parcel of notifying the tribunal, you have to give them the unique certificate number that appears on the certificate, so like a reference number. So that's the process overall. It doesn't stop there though, because after you've made a claim, of course, conciliation still becomes a viable proposition. What happens is the tribunal sends us a copy of the tribunal claim, and then we can pick up where we've left off in some ways. The only difference between early conciliation and tribunal conciliation is that with the tribunal bit, it's working in tandem with tribunal procedures, so you've got to be aware of things need to be filed, deadlines need to be met, that kind of thing. But the conversation with us will still happen as it did in early conciliation, so there's no difference in that respect. The other thing I would say is around time limits. Timing and time limits are very important. Critically, I think, any notification to us has to occur before the end of the primary time limit, the primary deadline to submit a tribunal claim. So generally for most types of claims, you've got 3 months less 1 day from the act complained of to make a claim to tribunal. So it's very, very important that anything that comes our way in terms of a notification is made before that deadline is reached. Once the notification is made to us, there is a pause to that deadline. So that gives us some breathing space and a bit of wriggle room to have these discussions. But if you come to us after the deadline, then obviously there's no pause at all. And that can have some serious complications, not least because the focus then is on, I'm possibly out of time to make a claim, so I need to crack on and start the claims process and obviously garner together arguments about why it's late. But I think in that scenario, the other downside, if you like, is that conciliation isn't really a realistic proposition. The imperative is about making the claim. Spending time in conciliation in that scenario really runs the risk that the claim becomes even more out of time. And of course, then persuading the tribunal to allow the claim in becomes even more problematic. So make sure that you get the claim to us in good time, certainly before the deadline. And that then, as I say, causes the clock to stop. It's obviously it's sometimes referred to stopping the clock. Well, that's exactly what it does. It stops that deadline, and then we can start to have a conversation. I think the other thing to mention is that putting aside the technical bits, the real benefit, if you like, to conciliation or the conciliation period is that you can have an open and frank discussion with an Acas conciliator. It's simple to take advantage of. It's a simple online form. It's free of charge, and it's confidential. So anything that you're discussing with us, anything you want to refer to us, is not something that will ultimately end up before the tribunal or the other side if that's the way you want it to. So it lasts for 6 weeks, but it can be a useful opportunity for you and your member to resolve the dispute relatively quickly, especially when you compare it to the length of time it takes to get to a hearing, which we know has been aggravated more recently by the pandemic and the already existing backlog of claims that the tribunal have been having to deal with. So listing claims now is longer and longer. I think the other advantage is that, as I said before, there's no guarantee that we might be able to resolve it in early conciliation, but engaging with us can pay dividends later on. So any tribunal claim that's made, it goes back to the same conciliator you've been speaking to in early conciliation. So that person will be very familiar with the background. They'd likely have already made contact with the relevant people, both with yourselves and the other side, and had some initial dialogue. So that kind of groundwork will act as a springboard, hopefully, to achieve a positive outcome shortly after even the claims made. I think that's all I wanted to say. Sorry, it feels like a bit of a whistle-stop tour.
That's fantastic, Tony. And actually, I think what we'll do now is take a few questions that have been posted specifically about what you've just been saying, and try and answer them now. We've had a small number of questions about. I'm not surprised here about time limits. So the first one is, just to clarify, at what point does the 3 months start? At what point in the whole process from incidents, when does that clock start ticking?
Well, the actual primary deadline, so the 3 months less 1 day, I don't know why it's less 1 day. It seems overly complicated. It should be just 3 months, shouldn't it? But nevertheless, that starts from the incident, if you like. So, and that could cover a multitude of things. So if you are dismissed, it's the effective date of termination. So that could be, if you're summarily dismissed, it's immediately you've been told to leave work. If it's with notice, it could be the end of the notice period. If we're talking about a deduction from pay, then it's the date of the deduction. So in other words, I was expecting to be paid on this date and I haven't been paid. That's the trigger for the 3 month deadline.
Thank you. And how would this work if it was, because someone else has asked again about the 3 months minus 1 day. If it was a discrimination claim, would it run from the end of the grievance appeal, or the act itself that triggered that appeal or investigation?
Yeah, it would be the act itself, and that's an important point. And you know, I welcome the question actually, because we do find that there's a bit of a trap there for some people, because they might raise a grievance about something, they might be waiting on the outcome of appeal for something, and in their mind they're thinking, well, I'll wait until the decision's been made and then I'll consider making a claim to tribunal. But in actual fact, the clock is ticking for them as soon as the incident's happened. So all the internal stuff is great and we'd encourage it, but if it means you might miss that time frame, there might come a time when actually you need to contact us and be thinking about, hang on a minute, you know, I need to get my notification in because otherwise I might be out of time.
That's helpful. Thank you, Tony. Again, related to the discussion around the timing and the clock ticking, we've had a couple of questions regarding members who might have a disability. So the viewer asks, what if the member we're representing is disabled and needs reasonable adjustments? disability is a protected characteristic under the Equality Act, and additional time is sometimes a reasonable adjustment. Is this something that you can authorise, or is it something that's possible to get extra time in this situation?
Unfortunately not, no. We have to work to the legal framework that describes how early conciliation works, and that has a certain interplay with primary legislation. So if you think about it, if early conciliation wasn't there and somebody had to make a claim on the basis that they had a disability and a reasonable adjustment wasn't made, they've still got 3 months to make that claim. If they didn't make that deadline, they could ask the tribunal to exercise their discretion on whether to allow a late claim in. And one of the reasons they might put forward is that, well, I've been struggling to deal with this issue. I've not been able to make the deadline because of other things going on in my life. That's detracted from actually thinking about a tribunal claim. And it wasn't until late that I actually understood what I needed to be doing. So there is some discretion at tribunal. That discretion would apply after early conciliation as well. So if you were late after early conciliation, the tribunal still has a discretion to hear, if you like, your reasons why. But that hasn't changed for a number of years, and early conciliation hasn't changed that at all. So there's nothing inbuilt intrinsically in early conciliation that adds anything more than what was there before, if that makes sense.
It does. Thank you, Tony. I'll ask one more question now about the time limits, and then we'll move on to the next bit of the webinar, and then we'll try and come back and answer some more. Is there any reasoning why it's 3 months less 1 day and not, for example, 6 months less 1 day, with the possibility of an extension for complex cases? Again, our viewer says that this time limit could disadvantage disabled workers who might have a mental health disability, who are unable to make informed decisions in a short time frame. Is there any reasoning behind this 3 months minus a day?
I think the original reasoning is that the tribunals were originally set up to be relatively informal. They wanted to try and resolve things as quickly as possible for all concerned while memories refresh, because obviously it relies on evidence. So if you need to examine what's happened in a workplace, and that involves witnesses, you'll want the evidence to be relatively fresh, so that it has a certain credibility and integrity to it. Unfortunately, as things have become more complicated, there's been more and more jurisdictions. We conciliate on something like 52 jurisdictions now, so it's a far cry from what it used to be. Lawyers have got involved. This raises other technical aspects to running a claim, and so I wouldn't disagree necessarily with what's being said. I think what used to be a happy medium and a relatively straightforward process, 3 months was sat well with that, but not so much now, because it's become more technical. And it's interesting because there's something of a debate about it. It's quite topical, because I think the Law Commission has looked at that very issue and talked about, actually, is it time for certain jurisdictions, so like you say, with disability or pregnancy and related matters like that, whether we should look to increase that substantially to take account of some of the issues that have been mentioned.
That's incredibly interesting, Tony. And actually, you've answered another question as a bonus there. Somebody else asked, does Acas have an opinion on the time limits? And you've told us there what some of the kind of things that are going on in the background that we might not know about. But we'll come back to other questions shortly. I don't want us, though, to lose out on the next section of our webinar, which is about the top tips that Acas have for you as workplace reps. So what we're really interested in is best practice ideas and recommended behaviours that might be useful for reps who are trying to reach solutions during the conciliation process. So who's going to go first here? Is it you, Tony, or Nicole?
I can't remember.
Yeah,
You'll go
I'll go
first. Go
yeah.
for it.
Yeah,
Let's give you a
I'll go.
chance to breathe for
Yeah.
a minute, Tony.
Yeah, and I can see from some of the chat that many of you have found it really useful, some of the information that Tony's given you. So I'm a hard act to follow there, guys, but I'll do my best with that. We were trying to think about what would be most useful, really, in terms of the opportunity we've got to sort of have a chat with you. And what we find is that we've frequently been asked by parties and their reps, how do I get the best out of conciliation, really, when I'm actually dealing with an Acas conciliator? Now, well, just to say up front, and kind of apologies if I'm not trying to teach people what is the blindingly obvious here, but it's worth saying in some senses that the process of conciliation is different to representing somebody at tribunal. The latter is very adversarial. It's a win-lose outcome. But conciliation is a process which is aimed at really finding a win-win. And those are terms that I'm sure you've heard, and you've probably had your own conversations about what that means for you as a representative when you're there clearly to act squarely in the interests of your member. But in our experience, we sometimes get parties or reps who come to us and they're a little confused, or they conflate those two arenas. So we thought that we would take this opportunity to talk to you and maybe think about a few tips that you or your member can use to get the most out of conciliation. We appreciate on some occasions you will be formally on record representing your member, and sometimes your member will be representing themselves but in regular discussion with you. So you can still, in that sense, be supporting your member even if you're not necessarily on record. So what we've tried to do is to maybe think of a few kind of key themes about what those top tips would be. And if I was going to state the first one, and this one's going to sound like a really obvious one, but it's ever so important, it's about being able to contact you. It sounds obvious, but conciliation is predominantly done by telephone. We do use email, but really there's no substitution for having a conversation in conciliation. As Tony said, early conciliation, or EC, I'm going to call it EC if you don't mind, because it's just a bit quicker to say. It's up to 6 weeks, but that isn't really a very long time. So if we lose time because we haven't got telephone numbers for people, or they're not really available, it's critical time that's being lost within quite a short window anyway. So we will definitely send you details of your conciliator's number. So as soon as we get the early conciliation form, we'll give you a telephone number that you can contact so that you can speak with your conciliator. I urge you, please, that when you're working with your member, or indeed on behalf of them, filling out that early conciliation notification form, please give us a phone number. You will probably be giving us an email address as well, which of course, we will be using as part of conciliation. But the real point is, if we can get you that contact number and we can get a hold of you, and you can encourage your member to be available during that period, to take those calls, to enter into conversation, it's a top but simple tip for getting the best out of conciliation. Just give us a contact number so that we can have those calls. So there's the first one, really simple, but you'd be surprised how many people don't give us those telephone numbers. And then we unfortunately end up wasting quite a bit of that time trying to get a hold of a number for them. The second one I would say is that EC form, which you have to fill out in order to begin the process, please encourage your member to fill it out as much as possible. Back in the day when EC was first introduced, there was only certain bits of information that you had to give us. You had to give us the name and address of the person making the potential claim, and the name and address of the employer or respondent. And that's pretty much it. The law doesn't actually require you to give us much more than that. Obviously, I've just made the point that we want telephone numbers and email addresses so that we can get that all-important contact going. But what we found is that a lot of people were coming back to us and they were saying, you know what, I was really surprised that there wasn't some opportunity to tell you something about what's been happening. And I really want to tell you, I expected to do that on the form. So what we've done over the years is we've developed that part of the form so that you can tell us what is the type of claim that is being made, give us some initial detail, etc., and fill it out as much as possible. It definitely hit the spot for users who were telling us they wanted to do that. And we are using that information now because we've now got a better picture of the case and we can get it to a conciliator quickly. So again, if you're helping a member to fill out that form, or indeed you're representing them, go through the form, tell us what it's about, and that's really going to be one of the top tips to get you into conciliation as quickly as possible. So that's top tip number 2, really. Fill out the form as much as you can. Top tip number 3 is really about giving us some information and doing a bit of preparation for yourself. So when you start looking at the form, it's going to be helpful if your member has had time to really think through, what is my case about? And we find that often if there's a rep who's helping, even if they're not formally representing, some of the best use that rep can be is to help their member think through what the case is about, so that when the member is talking to the Acas conciliator, they've got some of the details that are needed in order to inform the conciliator about the case, and they are ready to start talking about what the case is really about and how a tribunal might look at it. We do get people who come to us and they say, well, I haven't been paid my holiday pay, but they have no information at all about what are the relevant dates, etc. And that sort of information can be really useful when we go to the respondent to try to open up a conversation to see if we can get that resolved. So take some time to prepare your member. We found that some reps who have helped members do a bit of a chronology in terms of what's happened and the key dates. It means that when you get to talk to a conciliator, you've done a bit of preparation, and that conversation can get going pretty quickly and we can make use of the time. Another really useful thing to help your member to think about is, what is it they're hoping for with regards to settlement? So what is it they're looking for, at least initially? Because your conciliator may want to explore that with you fairly early. Now, we accept that may change as the discussions progress. So you're not held to anything. Don't worry if you come and you say, this would be what would sort it out, and then you find that through the discussion, you're going to be moving on that figure. You're not held to it until the actual final agreement is something that you're ready to sign up to. But again, it's a bit of preparation that you can do with your member, because you are likely to know more about the sorts of things they could get out of a tribunal. Giving them some advice, helping them think it through, means that when they have those conversations with the conciliator, they've already done a bit of preparation in their mind. So I would say that is the 3rd top tip. Do a bit of preparation with your member and get them to think about the details of the case and what it is they think they're looking for. And maybe before I pause, I'll go into just the 4th tip, if that's okay. And I think I'm going to call this a mindset, if I may. And it's kind of harking back to what I said when I started to talk to you about the top tips. There's a difference between the way that you're going to represent a member if you're in tribunal, which is very adversarial, and you want to be the winner on the win-lose side of that type of outcome. Whereas in conciliation, what you're looking for is compromise. Compromise oils the wheels of conciliation. And to have a mindset where you're open to talk things through, explore different areas, that can help conciliation get you to the point where more options can open up, and hopefully you'll be able to think about resolution. Just to provide a bit of comfort on that, if you think, well, I don't know if I want to really open up here. How safe is it to do that, to explore those sorts of things? Well, don't forget some of the points Tony was telling you. It's confidential. So if you want to speak confidentially to your conciliator and say, listen, I want to just get a bit more information here, and I want to explore whether this might be doable, but I don't want you to pass this to the other side, feel reassured that you can do that. And it can be great, in a sense, to be able to do that with someone who is going to be independent, and you can have that conversation without any fear of being passed across. And at the end of the day, if you can't reach that resolution, the tribunal process won't be stopped. The process will be there for you to use if you need to. All the time in conciliation, it's like free time to have those open conversations. So that requires a different mindset. And importantly, you may help to, in a sense, educate your member that conciliation is a different process to tribunal, because they may be expecting you to go in hard with the conciliator and just, tell them what I want. And they're the ones who suffered the problem in the workplace. So there's a lot of emotions around it that you may, in fact, be dealing with. So helping them to understand what to expect in conciliation is probably going to be really useful as well. So that's my fourth top tip, bit of a mindset for conciliation. And I'll pause there if that's okay.
Absolutely, Nicole. I think they are some fantastic tips. I don't know whether you're having a look at like one eye on the chat panel, but people are saying that this is really helpful and is really is really good to know. And actually, I think almost at the exact moment that you were talking about confidentiality, someone posed a question about what information is disclosed. So perfect timing, really. Tony, did you have any tips to add, or should we move on to answering some of the questions that have come in?
Yeah, I think just a couple of tips from me I can think of. I mean, Nicole's picked up on one of them, and that's the important relationship that you as representatives have with your members. So you give emotional and moral support to your member during what can be a very stressful time. And managing that is undoubtedly going to have some impact on you as well as a representative. So you're going to get stressed a bit with it as well. But I think the close working relationship you have with your members can really help that conciliation process. Like Nicole said, you're ideally placed to have those conversations with them about what's realistic, what's achievable, what you need to understand, and be able then to feed back to us. And so we can really, get into a constructive discussion about trying to resolve the matter. So in a sense, the top tip is keep doing the good work that you're doing, because it's really, really important. Your relationship with your members is fantastic to us. I think the only other bits that I had, if you are, please let us know if you are representing your member formally. So I recognise that every union's organised differently, and some representatives might just be supporting a member in the background without necessarily taking a more active part in dealing with the claim. But if you are wanting to be actively involved, then please make sure that your details are on record, because the Acas conciliator will only be able to deal with you if you are formally on record. If you're not, they'll be having a discussion directly with the member. Also, if you are formally taking an active part, then don't forget to keep the member informed of what's going on. Sometimes conciliators report back to me that where members feel as though they aren't getting up-to-date information or feel a bit left out of the loop, what they'll tend to do is ring the conciliator. And that's the last thing we want to do, because obviously we're having a discussion with you. We want to keep things on track, and it can kind of upset the apple cart a bit if we've got claimants on the phone saying, what's happening? I don't know what's going on. Sometimes they'll want to take a more proactive involvement, and all the time we're thinking, actually, are you sure this is what you'd want to do in the absence of any advice from your representative? So it can just be a bit problematic for us, that. So by all means, if you are taking a back seat, fine. But if you want to be actively involved, then please let us know, either on the notification form or as soon thereafter if you can. Last thing probably from me is around time limits, and I'm just playing to the crowd now because obviously there's a topic people enjoy, so I'm just going to talk about time limits all the time. No, what I was thinking of is that the calculations to determine when the claim needs to be made after conciliation can be very, very tricky. There's a statutory formula that talks about day A, day B, and then there's another bit to it. I mean, there's some mental gymnastics that you have to go through to try and do that. By default, you've always got a month. And you might have heard this a lot from our conciliators. So they won't try and work out the deadline for you or the adjustment to the deadline based on the time you spent in early conciliation. They will rely on the fact that the legislation by default gives you a month from when you get your certificate to make the claim to tribunal. So it's dead easy to remember that. I've got a month from when I get the certificate. But my top tip is, why hang around at all? If you're going to make a claim to tribunal, that's where it's going. Why wait at all? You can get the wheels in motion. don't forget you can be talking to us alongside doing all that. So that it's not a stop-start process. You can continue to conciliate. You can continue to conciliate after the tribunal claim's made. So, you know, don't play chicken with any deadline. It's far better to you know, progress matters where it's going that way, and there's no, you know, obvious reason to delay matters.
Thanks, Tony.
I think that's it. Yeah.
Yeah, that's great. And there's nothing wrong with playing to the crowd. Always good to give them what they want. Right. We've had a lot of questions. I've tried to pull them out in batches here. So we've got some questions which are purely about the logistics, the practical side of things, and then some more that are a bit more detailed. So I'm going to try and get through the practical ones, seeing as we can answer as many of those as possible. I think they're being asked from viewers who really just, you know, want to know about that day-to-day process of the conciliation. Okay, so the first one, does conciliation occur with all parties in the same room, or is it more shuttle-based, as they've put it? I think that's a good way to describe it. So you're both unmuted, so feel free to sort of jump in, and I'll answer these as you feel appropriate.
Yeah, I'll start if you like. You will find that if you're helping a member or representing a member, that the vast majority of conciliation is done by telephone in separate conversations. So to use that term, shuttling is exactly what you'll find, and that will be done on the telephone. So that should probably be the experience that you have on the vast majority of cases. Obviously, the pandemic has affected face-to-face meetings in a big way. But if I'm going to be honest with you, where the demand massively increased a few years ago, our conciliators found that to go out and do individual visits or face-to-face meetings, obviously they could do a lot more by being on the phone to parties than they could by doing that. So we had to, in a sense, cut our cloth there. And that's where most of the conciliation will take place. We have got a few people who have done some video calls with those who would want to, and being able to see people can sometimes be comforting to a party to see their conciliator. On occasion that's possible, but it's quite dependent on the technology that's available. And in some of the bigger, you might call them group claims, collective type of issues, certainly traditionally getting people around a table and then possibly sometimes putting them in rooms, doing some shuttle conciliation and then bringing them back together was the traditional way of doing it. But again, that has had to change since the pandemic. So I think the answer to that really is that for the lay members, what you would probably find is if you're involved with an individual member who's got a case that's running, you should expect it to be largely by the phone, and that the other party will not be on the line at the same time as you.
Thanks. And moving almost immediately on from that question about phones, are these phone calls recorded for use later down the line?
No, they're not recorded. They're not. I mean, there may be occasions where a manager is listening to the call in order to either support the conciliator or indeed to be able to coach and develop that conciliator with their skills, make sure that they're keeping up with the right sorts of advice that is given. But those are people who, as I say, they're managers of those teams. We make no recording, and so the conversation is only between the parties on the line. That's
really helpful. Thanks, Nicole. Another question that's come in about the practicalities is, can you ask for a conciliator of a particular gender, depending on the facts of the case or the the preference of the individuals concerned?
Now I'm not going to be able to play to the crowd here, because if that were a popular request, I'm afraid I'm going to be unpopular in saying no, we don't allow conciliators to be cherry-picked. For that reason, they could be cherry-picked, and you may have a trade union rep who gets on particularly well with a conciliator, always asking for them. You may equally get a respondent who thinks, oh, I've got a really great relationship with a conciliator, I always want to work with that person. The idea is that all our conciliators are fully trained, and you should be able to get the same service from all of them. But what we don't want to do is to create a scenario where either side may feel that they're getting some level of advantage by being able to cherry pick a conciliator. Even if the intention is to get a level of comfort, it can be seen by the other side as advantage. So we want to make sure we continue that level of impartiality and independence.
Sure. Can early conciliation be subject to a non-disclosure agreement?
Do you want me to take? I feel I should take one now, Nicole.
Go on, yeah, go ahead, yeah. I'm happy for you to take that one.
Yeah. Well, of course, with conciliated agreements or COT3 agreements, it's not uncommon to see confidentiality clauses within the terms of a COT3. So, in other words, if parties are at the point where they're agreeing terms, part of those terms might be to pay a sum of money over. In return for that, then obviously the individual will be waiving their right to take the claim further to tribunal. But there are often a subset of other terms where both parties are, have some input into. So we start with a blank piece of paper essentially, and then either side can decide what terms they want. In terms of whether conciliation can be subject to a non-disclosure agreement, well, that I'm not quite sure what that means, but as Nicole said, we wouldn't be disclosing anything to anybody anyway, because there is statutory protection for our discussions. So in other words, the law says anything communicated to a conciliation officer in the course of their duties is inadmissible before a court. So there will be no need for a separate agreement that says this, essentially the same thing. Certainly that's how we view our role, is to be very protective of the conversations that we have.
Thanks, Tony. That's really helpful. I'm just looking here on the other questions that I've pulled out. Right. Does the employer have a legal obligation to enter conciliation? The viewer in particular asks here, or they say that their employer doesn't seem interested in Acas until they get to the ET stage.
Well, there isn't. I mean, there's no compunction on either side to take part in early conciliation. I mean, it's mandatory to let us know before you make the claim. So a notification has to be made, but either side at the end of the day can say, actually, I'm not interested. I don't wish to engage. And we wouldn't push the point. There's certainly no penalties at tribunal. I think it's just a question of, I mean, we would obviously say there are benefits to be had to engaging with our process, but it's a personal choice. And for some employers, I can imagine that they might be sat there thinking, well, actually, I don't think anything will come of this. And it's only until the ante's upped a little bit and the claim's actually made to tribunal that suddenly it's, oh, maybe I should start having a discussion about this now.
Yeah, I mean, it is true. There are employers who may take that initial view. Certainly, there are other employers who take the view, if the tribunal process is started, then basically, unless I can resolve it or it's withdrawn, then I'm into quite a lot of costs and I've got to go to a hearing. And sometimes that's the sort of thing that brings those employers to talk to us at EC stage. They realise there are real benefits for them as well in resolving it before all that legal process gets started, a process that the claimant is in charge of starting and is in charge of keeping going if they choose to. So we'll be using all those sorts of arguments to try to bring a respondent into conciliation. But yes, some of them will say no. Some claimants say no. Some claimants simply want their certificate. They fill out the form and they don't want conciliation. So yeah, another top tip, please encourage your members to use early conciliation. It's a pause in that clock, free time, free service. Really, why wouldn't you?
I think that's really key, Nicole. Thank you. It stops the clock, the all-important ticking clock, which I'm sure trips many people up in this process. Right. So this is a bit of a broader question. Do you have any idea or, evidence of how many cases settle at the EC stage rather than after a claim being submitted?
We do. We collect statistics on it, and what I would say to you that for those of you, I'm going to say this now without meaning any insult at all, for the nerds amongst us who like to look at, annual reports, etc., and I'm one of them. If you go onto the Acas website and you put in the search engine Acas annual report, you'll be able to see a whole raft of statistics there. And what we do is we break up the statistics to show how many notifications we receive, how many we settle on a COP3 agreement, how many of those, what percentage of those go forward to the tribunal. We'll even break it down by jurisdiction for you in terms of, how many of them tend to fall within discrim jurisdictions or Wages Act, etc. Broadly speaking, I would say we're probably 20% plus in terms of those at EC that are settling on in a formal COP3. But bear in mind, and actually it's a great opportunity to probably raise this, there are other ways in which resolutions can sometimes be met that don't end up on a COP3. So it's not unusual that if an EC notification is raised and some discussions get started, that a respondent decides to pay up some wages that may be due. They don't necessarily do it on a COP3, but the conversation gets them thinking and they decide to pay up and the dispute has actually gone away. Less likely in things like discrimination, of course, but some of the conversations that the conciliator will have sometimes make a claimant feel, actually, I've overestimated the strength of my case and there'd be real risk for me if I went ahead. So they may not reach a resolution, but they are informed about their decision not to pursue it. So I would say that probably in terms of the number of notifications that come in, about 3/4 of them never go on to make a tribunal claim, because there are those many ways in which you can find you are resolving the dispute at that point.
Thanks, Nicole. And there's nothing wrong with being a nerd. I love a good statistic
Thank
and
you.
indeed a chart. So, you're in good company. Okay, I think we've probably got time for 2 more questions. So, in your experience, are more successful outcomes reached when Acas conciliators speak with the impacted employee or their representative?
Ooh.
Is that too close to call?
I think it probably is. There's a lot of different dynamics that would come into play there. It'd be difficult to try and guess on that one. I'm not trying to dodge it, but it's very, very difficult to say.
We certainly don't have any statistics about it. And in terms of a gut feel, what I would say, and this is my opportunity to play to the crowd, is that if you've got a rep on board who has that mindset about wanting to find resolution without going to a tribunal, in my experience, they're invaluable, absolutely invaluable, because you're going to be having conversations with your members that even if we have frank conversations with them, you've got a different relationship. There's a different level of trust and expectation that they have with you as the representative. So if a rep is on board, they can absolutely be invaluable, whether that be that they are on record or are helping the member to stay within the sort of the reality of the situation and can help provide some information too. So I don't know that I've got any feelings as to whether you reach resolution easier, but I think the process of conciliation, there's definitely a role for a good rep if they're following those tips, definitely.
Excellent. Let's see if we can answer this one as well. What is the difference between conciliation and arbitration? Is there one?
There definitely is, yes. Conciliation is, it's the outcome of conciliation is very much driven by the parties themselves. So it's about distilling compromise into something that works for both sides. If you're going to arbitration, normally what you're wanting is an arbitrator to make a decision on your dispute. So that's very, very different. So in other words, you're handing over your dispute to an arbitrator, and the arbitrator will decide, what the outcome should be. Conciliation is much more in your control. It's much more fluid. It's much more flexible. I think that's the way I'd describe it in simple terms. There's probably some very technical differences that underline all that, but in simple terms, that's the difference I see.
Yeah, I'd agree with that. And similar if you go to a tribunal, isn't it?
Yeah.
There's a judge who will make a judgment, and you don't have the same level of influence over that. You can only present your case and hope that the judge agrees with you on that.
Thanks, Nicole, and actually thank you both there. I mean, we've sped through an hour incredibly quickly. We've only really answered a fraction of the questions that have been posted. So now there's a final question that I'm going to put to you two, and hope it not putting you on the spot too much. I really think it would be helpful if we organise another session, maybe in a month or two, early in the new year, where we could return to some of the topics that we've only really touched on today, because I think people have found it incredibly useful, and they've really benefited from sharing their experiences and hearing the top tips from you. So hopefully we can arrange something for the new year where we can return to some of these. I'm wondering whether you can see the chat is sort of zooming by with people saying excellent session, really informative. And there was someone a few minutes ago who said that they were regularly use the Acas services, and it's just incredibly helpful.
Good to hear. Thank you very much.
Yeah, it is really good to hear. And we've learned so much today about the role that you play and your top tips to workplace representatives. So thank you very much, Nicole and Tony, for joining us. Thank you to the hundreds of people in the audience who've joined us today as well. And we'll see you again for another TUC webinar. That's all from us. Bye-bye for now.
Bye.
Thanks everyone.
For inviting us.